Hi, today's council perspective comes from my dear friend and colleague Guilherme Recena Costa. I had the pleasure and honor of working with Guilherme many years back. We were together at the same law firm for many, many years in New York, several years back, and since then has been a very close friend. I am proud to have seen his exponential growth in arbitration and how he has become a reference in the market and for so many issues. Guilherme, thank you for being here today. Guilherme brings the ideal council perspective. So I'm particularly excited to talk to you today because Guy is tri-qualified. He's qualified in Brazil, in New York, and is also a solicitor in England and Wales. But as I mentioned, he practiced as external counsel for law firm in Brazil. He's also practiced many, many years for an international law firm based in his offices here in New York and also in the UK, and has since then shifted his career to become head of legal Latin America for Barrick Gold, which is a role that he has right now. Additionally, Guy also provides a true 360 perspective because he also serves as an arbitrator. So honestly, as you can see, no one better to give us like a full 360 entire perspective of what it is to be working in international arbitration. Guy, again, thank you for joining us today. I'm truly excited to be here with you, and I'm very much looking forward to our conversation.
Thanks.
We have.
I just want to underscore some words of gratitude first to Lucila and to the folks at Canal Arbitraje, Laura and others for the very kind invitation to be here. Obviously to King and Sporting as well, who's hosting us with the wonderful view that we have behind us. And I would just note for the audience that the very complimentary introduction that Lucila made is a lot attributable to our friendship rather than anything else. So thank you for the invitation.
Thank you, Guy. Glad to have you here. So I want to kick it off by addressing one of the key questions that burns in every in-house counsel's mind and from us as practitioners in arbitration when addressing disputes. You know, the typical dichotomy. I mean, do you go to litigation? Do you go to arbitration? So in your views, what are the pros and the cons that you see in arbitration when compared to litigation?
So I think, and of course, in my current role as in-house counsel, this comes up more frequently because I'm now in the role where I'm negotiating a lot of the agreements. So I'm thinking about this ex ante rather than as external counsel in arbitration. You are hired once a dispute arises, and precisely because there's an arbitration clause. So it does get you thinking a little bit more profoundly about the pros and cons of each. And what I've come to realize is that the true advantage of arbitration, in my opinion, is really neutrality. So when arbitration is really useful is when you have, and this is, I guess, the classic archetype of arbitration and the way it was thought up to be, at least in the international sphere, where you have parties from different jurisdictions. They are both uncomfortable with the courts of a given country, maybe because one of them has a home advantage. Sometimes it's simply because both parties operate in a specific country, but don't have really sort of the depth of operations in that country where they're familiar with the legal system. So they want to go for something which is one, neutral, and two, familiar. Right? I mean, having said that, we all know that sort of the usual things that are said about arbitration and other advantages like the confidentiality of the proceedings and, you know, the greater control that we have over both the procedure and obviously the composition of the tribunal. But neutrality for me is today the really sort of salient point with picking between courts and arbitration.
So, and as you've noticed, arbitration has changed quite substantially in the last 10 years. Would you still prefer arbitration over litigation?
So I think now my view on that has changed a little bit, as in before I would always say, yes, let's go to arbitration. But again, maybe when you have a hammer, everything looks like a nail, right? But now I would say it depends. And it really depends on sort of the juggling of these factors that we were talking about, in particular, sort of neutrality and familiarity with the court procedures. I think I can now see the benefit that a wide array of disputes actually ends up in certain courts rather than arbitration, because courts also have certain advantages over arbitration. And I guess we're going to be talking a lot about why it is that arbitration might be losing some of its advantages and that sort of this gap between arbitration and litigation may be closing. And I think now, sort of sitting on the other side of the table, if you will, as in-house counsel, I can see how a lot of my counterparties in these negotiations actually don't want to go to arbitration. They want to go to litigation. And in many courts around the world, which are sophisticated and fairly efficient in both terms of sort of time and cost, that's a totally acceptable choice, right? And so I think, again, it's becoming a little bit of a more complex decision, which might be both a good thing and a bad thing, right? It means that there is a convergence of sorts between litigation and arbitration, which could mean you have two viable choices on the table rather than just one. But it also means that we, and I still consider myself very much sort of a first person, we, the community of arbitration users and providers and arbitrators, need to think very carefully about how we position arbitration so that we can really sort of expand upon its advantages and make it a more salient choice for parties.
Then what do you think has changed the most, or sort of the salient change in arbitration during the last decade plus?
I think the most salient change has been that arbitration has become increasingly formal and rigid. And I know this is something that has been said many times, but I think it's increasingly the case where every year somebody comes out, gives a keynote speech, we talk about the shortcomings of arbitration and how it's getting excessively rigid, excessively formal, but we as a community actually fail to take action to do something about it. I mean, there have been improvements and changes like, expedited procedures, and I think there's now a greater willingness to accept, for instance, sole arbitrators rather than a three-member tribunal, which obviously obviates a lot of the cost up front with selection of arbitrators, but also in terms of fees. But I think this rigid mindset has really permeated our practice, and we are we're very much confined to sort of a template, and that really sort of jettisons one of the big advantages of arbitration, and it's almost like it's reason for being, which is the parties have autonomy and control over the proceedings.
And touching on party autonomy and control of the proceedings, you've switched, as we mentioned, from external counsel to in-house counsel. So in your view now, from the in-house counsel perspective, what do you think is the role of in-house counsel throughout an arbitration proceeding? Do you like to be participating in pre-hearing conferences and throughout the procedures and taking more of an active role? I mean, in calls with the tribunals, what are your views on that?
So I think in-house counsel have an absolutely crucial role to play in the arbitration process, because again, the point I think that we're both getting at with this rigidity and formality, it's not a problem of negotiating arbitration up front in your contract, of including an arbitration clause. The arbitration clause is often very broad and flexible, and most of the rules are very flexible and delegate a lot of power and autonomy to the parties and subsidiary to the tribunal as well. So it's really a problem of engagement. And I think we have just been failing as a community as a whole to sort of engage with the process in ways that are creative and fit for purpose. And a lot of those failings really do, I mean, the buck ultimately stops with in-house counsel, because we are we're the people who are ultimately making the decisions on instructions to external counsel. But I do think it's really just a combination of external counsel, one, educating in-house counsel, who many times are not typically truly familiar with arbitration. A lot of my colleagues are transactional lawyers who are not sort of litigation-bred attorneys. And of course, arbitration within litigation is also a somewhat niche market still. But secondly, also being a little bit more proactive in offering advice and sort of outlining alternatives, right? Like really thinking about whether the procedure is fit for purpose, where it can be made more efficient, where it can be made less costly. And there's a bunch of things we can do, but I think we are too quick to default to, again, this template, which has become increasingly rigid. And one thing I would note, and this is sort of, obviously, a lot of this is speculation because we're talking about these grand movements in the profession as a whole, but I think in the same way that commercial arbitration served as the archetype for investor-state arbitration, and so us, investor-state practitioners, borrowed from commercial arbitration in terms of how the proceeding should move along. Investor-state arbitration, which is of course very complex, very sort of heavy by its very nature, and the asymmetry that exists between the investor and the state. So investor-state has made our idea of arbitration very much complex and rigid, and sort of, I'm using the word heavy because it feels like a heavy proceeding, right? It's almost like a burden to carry it forward. And I think the problem has been that a lot of the investor-state developments have been basically imported back in a reverse movement into commercial arbitration without us as a community giving enough thought to whether that makes sense.
Makes sense. Now, in your case in particular, do you prefer to be involved throughout all of the nitty-gritties of the procedures throughout the arbitration, or would you rather leave it on
I,
into external counsel's hands?
I absolutely prefer it, but it's because I love arbitration, right? And I'm sure that the external counsel that I work with now almost get annoyed with how involved I might get. But I do think it's better to err on the side of over involvement rather than under involvement. And a lot of it comes back to, well, if you all have these complaints about arbitration is getting too costly, it's getting too delayed, the procedure's too rigid, then, I mean, we can only have a fair complaint as to arbitration, as in a criticism of arbitration, if we as in-house counsel are properly involved in trying to avoid these outcomes, right? So my point here being, a lot of this, or I would say almost all of it, is within our control as a profession, right? And again, it's the interaction between external counsel, like you, somebody like you who's very proactive, is always coming up with efficient ideas and really making a tailor-made solution to the dispute, and then people like me to listen to what you're saying and actually have, it's almost like the courage to shift away from sort of the template that we've been talking about, which is too rigid. And by the template I mean a bunch of submissions without page limits, very extensive document production that goes on and on forever, essentially, in like red flint schedules going back and forth. Then we have very long hearings, sometimes longer than they should be. And at the end of the hearings, we have both oral arguments and we have post-hearing briefs. We often have 2 rounds of post-hearing briefs. And so any given dispute today becomes a really cumbersome thing. And I mean, that's when sometimes you look at the courts, and I mean, the whole point of moving away from the courts was, well, in large part it was because it was a cumbersome and inefficient proceeding. But now you go to certain courts and you have a lot of things which the courts have tried to adapt themselves to, like obviously motions to dismiss in the US, but in other places as well. So motion practice generally, but page limits and more concise arguments and sort of more narrower resolution of the disputed evidentiary issues, and frankly decisions which are much more to the point and sometimes well reasoned than some of the arbitration awards we've been seeing as of late.
Interesting. So the statistics lately, particularly this year, have shown a big drop in arbitration filings in all of the major arbitration centers. It is difficult to understand the reason for the drop, although, of course, the current economic climate might have a significant effect of it, and is influencing companies' willingness to start new disputes. But might there be other causes? Is it the looming recession? Is there a loss of faith in arbitration, as we have been talking about? Or might there be companies moving towards more use of mediation or conciliation or other EDR methods? There is indeed a feeling that clients are not willing right now to start new disputes, are holding off because of the economic background. But what are your thoughts? What are you seeing from the in-house perspective?
I think, to pick up on the expression you used of the loss of faith, I think all of the things that I've been saying now, and I'm saying them truly as sort of constructive criticism to me as well, as again, considering myself very much an integral part still of the community of arbitration users and professionals. But I think we have to take stock of these criticisms. And as we just said, the first one is it's become inflexible, it's become lengthy, it's become just too heavy, right? And there's an article that I'm a big fan of called The Town Elder Model by David Rivkin, our former colleague, in which he was talking about this. Maybe, I don't remember the date of the article, but it's like from 10 years ago. And you can see how those problems have just been aggravated with the passage of time rather than properly addressed. And so this is what we've been talking about until now. I think secondly, and this is a big, and I know obviously we're speaking to Canal Arbitraje, so we have a big Brazilian audience, but in Brazil, and I would say at least in the investor state space, enforcement has become truly problematic. It is now often the case that even if you get an arbitral award, a lot of companies will view that as a Pyrrhic victory of sorts, because enforcement is just so costly, it's so long, and ultimately many companies will have to settle to get cents on the dollar, that it becomes, again, sort of a Pyrrhic victory. And when you do a cost-benefit analysis of, well, is it worth bringing a claim, given that I'm going to have a lengthy proceeding, and that's really just one half of the battle, because I then need to go to an enforcement court. And awards, especially in Brazil now, there's a wave of attacks on the validity of awards through annulment actions. Some might be well-founded, some probably not. But in any event, the courts, the combination of perhaps too many conflicts on the arbitrator side and just a greater willingness to entertain these challenges has meant that there's always a big question mark over any arbitral award. And for a client, when you're trying to give your own internal clients sort of business certainty as to what we have, that is problematic, right? Now, of course, many people will say, and we had talked about this before the show, I guess, how, obviously there is a market for arbitration awards out there, and I think third-party funders and other similar sort of investors have a role to play in sort of making this a more liquid investment. But that's not ideal for a company, right? You want to enforce your rights. You want to obtain proper compensation. You don't necessarily want to have to take your piece of paper and go to market and get, again, as I said, cents on the dollar. And I think the third and final point I would make just on things that might cause clients some recalcitrance, I would say, in bringing you disputes is, and it's something I've been saying for a while now, but is perhaps the lack of certainty of outcomes in arbitration as compared even to court litigation. And of course, the whole point of arbitration is you're going to specialists who really know the industry, who really know the law, and you want to, and part of that is, of course, you reduce the sort of margin of uncertainty because you go into true experts, and so you should be able to predict the outcome. What is actually happening is probably an inverse process, which is fueled, in my opinion, in large part by the fact that, of course, most commercial arbitration awards are confidential. And this is, and I've had this conversation in the past, but it's a big problem in Brazil, where basically 100% of important corporate disputes now go to arbitration, not least because the B3, the stock exchange in Brazil, has a requirement that for you to list at a certain level, you need to include arbitration agreements in the bylaws, right? So everybody's going to arbitration, but then these decisions are not really known beyond a very tight group of both arbitrators and external counsel. And for clients, it creates a sort of black box, and it really hinders, in my opinion, the development of the law. And I mean, it's not the topic of today, but I think it's an important reflection that we need to make. And I think the ICC has really paved the way here for a truly important development in pushing parties to publish awards, right? Pushing parties and institutions. And for me, it really just boils down to sort of a temporal question of, yes, today, the dispute, when it's ongoing, it's important that it be private, that it be confidential, and that's important for me as a client now. But in 2 years' time or in 3 years' time, kind of like, who cares, right? So it's really the passage of time moots concerns over confidentiality. And so I think the solution in the 2019 ICC note of saying, well, in 2 years' time, we're going to publish this, maybe it's redacted to anonymize it, that would be a really good thing, because then folks like me now, instead of the in-house chair, you can look at these awards and you can say, well, I want to go to arbitration and perhaps I want to appoint this arbitrator or that arbitrator because they seem to have views of the world which are aligned with our needs as a company.
Great. I'd like to turn now to another aspect that's been under, stringent criticism in our industry, which is double hatting. That is, having lawyers serve both as party counsel and arbitrators at the same time. That practice is increasingly frowned upon. More stringent and clear rules are being developed precisely to limit that double practice. More practitioners are opening up solo shops as arbitrators precisely to prevent conflict or the impression of conflict and the double hatting dilemma. So what are your thoughts on double hatting in arbitration?
I think double hatting is generally a problem. But I think it's much more pronounced in the investor state sphere than in the commercial or the construction space. And the reason for that, of course, is investor state disputes follow a certain standard, right? They are, by their very nature, asymmetrical disputes that are pitting an investor with certain interests against a state with certain interests. And those interests tend to fall within sort of a general type or a general archetype. And so there, I think the issue of double hatting, and in particular issue conflicts, is quite problematic because you do have this situation where an arbitrator might be giving an opinion as part of an award, which could benefit his or her private practice as counsel to either a state or an investor, and vice versa. So I think, especially in the investor state sphere, which I think naturally has drawn more attention and criticism, it's a real problem, and it's something that we as a profession need to think about how to overcome. I see it less as a problem in commercial disputes, and I would have no problem at all appointing a colleague like you or anybody else at one of the big law firms, so long as there's no conflict per se. But like the issue conflicts, again, they're much more difficult to arise in the commercial context because there is no asymmetry, right? It's almost like it's a Rawlsian veil of ignorance where you don't know where you're going to be tomorrow. Are you going to be advocating on behalf of a purchaser or a seller in a share purchase agreement? You don't know, right? So generally, the tension isn't just as great with commercial and construction.
Construction. Now, related to this topic, and speaking of double hatting, do you see the same issues when it is in-house counsel serving as an arbitrator?
So that's a good question, because I think, we've increasingly been seeing in-house counsel take a more prominent role in the arbitration bar as arbitrators. And I think in the past, there had always been a notion, and I certainly always thought this way, that somebody who's spent some time in-house, like a former GC or somebody who's fairly senior in an organization of the sort, would add a lot of value to a tribunal because they would bring in sort of this different point of view, which is the client perspective, as I was saying today, but it's really an industry perspective, right? It's about how things get done. It's these experiential propositions that you obviously have as an external counsel because you're vicariously living the company's existence, right, as external counsel. But as in-house counsel, you're much closer to the business. So I think these people always had something to add. Now, the shift now is I think there's more and more appointments of in-house counsel as arbitrators while they are serving as in-house counsel, which is obviously the question you asked in terms of double hatting. And I think, and this, people will take this with a grain of salt because I'm obviously sitting in the in-house chair now, but I think there's less of a double hatting issue with one big, perhaps, proviso, which is, I think for the arbitrator, the in-house counsel to sit on disputes within his or her own industry is problematic, or could be problematic depending on the type of dispute, because you could have the similar situation of the investor-state arena where there are sort of these market positions between, say, a supplier of goods and a taker of goods. Or, in the mining industry, for instance, if you're working for a major mining company like I am, you obviously have certain issues on which you might have a very different worldview from in-house counsel or basically the industry if you're on the junior end of the spectrum of mining companies, right? So for earning agreements and things of the sort. So at least in my view, in terms of how I would view appointments, I would tend to steer away from mining disputes because I think there you could have the same, or at least the potential for the same type of issue conflicts that you have in investor state.
So related to that, I mean, in your experience from in-house counsel serving as an arbitrator, how do you navigate conflicts, issues, manage time, and so forth when you're doing that double hatting from that role?
I think it's obviously more difficult for in-house counsel to manage, not conflicts because you have a sole client, so that's fairly easy to clear, right? But again, if it's within your own industry, I would be very cautious about taking an appointment, and I'd be very cautious about appointing somebody who's in-house counsel in the industry that I would, out of which the dispute arises. So it's much easier to clear legal conflicts. It's perhaps much harder to clear issue conflicts, as we were saying. In terms of sort of managing time, I think that really creates a difficulty for in-house counsel because you have this standing client with ongoing needs. And of course, one of the things, and to link this back to where sort of we began with all of this, is one of the reasons why arbitration has become more rigid and perhaps less creative and slower is people are not devoting enough time to it. And a lot of arbitrators don't devote enough time to it. So it's truly important, I think, for everybody involved in the process to treat it seriously. And for in-house counsel, that means you have to carve out a chunk of time. And it may be that you have to use your vacation period to do a hearing or something of the sort. But I think it's doable. But again, it needs to be planned, as I think you said before.
And what do you see are the advantages of having an arbitrator that is in-house counsel versus external counsel, or that solely serves as an arbitrator?
I think the advantages are, I'm a big believer in generalism and diversity. And so I think in-house counsel, and I say this again, having sort of done both things at this point. I was through a much greater period external counsel than in-house counsel, which is a fairly recent transition for me. But even within a year into the job, I can tell that I've learned a lot as in-house counsel. And I've learned things that even if I were to make the greatest effort possible in terms of sort of a learning curve as external counsel, I couldn't learn because I just wouldn't have access to the business realities of a particular company and the day-to-day sort of decision making of executives and other people, which is again why I think a lot of external counsel place a premium on appointing former GCs as arbitrators, because they do bring this sort of sense of business reality into play. And I think in-house counsel also tend to be, as I said, both sort of diversity of thinking, but also a premium on being a generalist rather than a specialist. And of course, we are all in one way or another specialists in certain fields, and I certainly consider myself a specialist in arbitration above everything else. But the fact that as in-house counsel, you are by necessity called to address a whole host of issues that goes well beyond your initial realm of expertise means that I also think you bring to the table a different way of thinking about problems, right? Which might not be just confined to arbitration and the procedures of arbitration, but could take into account these other propositions, right? So again, business realities or just problem solving in general. And of course, in-house counsel will not only have litigated disputes over the agreements that give rise to the particular dispute at hand, but they will have negotiated those same agreements, right? So you have sort of the, as you said before, sort of the 360 view of the whole sausage factory that is drafting, negotiating, and signing and executing an agreement, all the way through sort of contract management and how a dispute develops over time, to negotiations of settlements and failed negotiations, all the way to the dispute. So I think it's really about bringing a broader perspective to the table.
You touched briefly on diversity, and that provided a perfect segue to our next topic, which is diversity indeed. How do you go about as in-house counsel to make sure that external counsel that you appoint, that tribunals and even experts are diverse?
I think this is a big and prevalent theme to the arbitration community. And I guess there's two ways to look at this. There is sort of diversity for diversity's sake, because it simply is the right thing to do. So we want to have diversity because diversity is in itself a value that we cherish and that we should promote. But I think for clients in particular, diversity is also a question of improved decision making. And it kind of goes to the point that we're making before, and hence you said it's a perfect segue, because it is. You want your tribunal, to the extent it is a 3-member panel, to be diverse in its thinking, right? You don't want them to be beholden to group thinking and sort of set in their ways. And as you might recall, I mean, from the beginning, what we were saying is that we become too rigid, we become inflexible. So if you have a rigid and inflexible procedure with which there is some dissatisfaction, you're not going to change it if the same people who devised that rigid and inflexible procedure and sort of set in their ways continue to be appointed over and over and over. And so my point there is, I think diversity also, it just goes well beyond race and gender, which again, are super important things and are values in and of themselves, but it has to do with different backgrounds. So, some people will have more of a business background. Some people will have been in-house counsel who would combine business and legal backgrounds. Or I think there's a crucial debate on sort of diversity of age, right? And we live in this sort of very fast-paced world, which kind of develops and changes day to day. And yet the people resolving these crucial disputes, whether it's between investors and states or maybe commercial disputes, tend to be of a particular generation, and again, somewhat set in their way. So it's good to bring in these new perspectives. So different national origin, different age groups and generations, different educational backgrounds, right? And a lot of this falls, again, the buck kind of falls with external counsel and in-house counsel, because external counsel typically the folks who will make recommendations of arbitrators. So they will draw up, as everybody knows on the call, I think, they will draw up shortlists, send that to in-house counsel, and the in-house counsel will have some input and will probably pick exactly the recommendation that was made by external counsel. So external counsel have to be a little bit more courageous in going outside the circle of the usual suspects, but at the same time, in-house counsel have to equally step up and be able to say, well, we are going to pick this, young woman out of a developing country because she's perfectly well qualified and she would actually bring a lot of value to this dispute. But that tends not to happen, which is why we always end up with the same arbitrators and again, so the same experts, where I think it's just a question of expanding the pool.
So what role do you think institutions play in making sure that we have diverse panels of arbitrators, particularly?
Obviously institutions are empowered to some extent to contribute to this. And I would say actually that institutions were the driving force behind this change, even though they can only affect so much of our choices. Within that realm, I think institutions like the ICC, the LCIA, the AAA, all the big reputable institutions, I think they have pushed towards greater diversity. And you can see this in, say, sole arbitrator appointments or default appointments in general, or emergency arbitration procedures where you have an appointment. Generally, it's been in those situations where I've seen a greater push for diversity. Whereas again, when you're thinking about the wing arbitrators appointed by the parties, or maybe even a chair who is appointed by agreement of the parties or the party appointed arbitrators, that tends to fall more within the sort of stereotypical arbitrator, right? With the same background, of the same age group, perhaps of the same race and gender, as we typically see.
Yeah.
So in this, I think institutions are, they deserve a pat on the back and kudos.
So other than that, what else can we do to improve diversity in arbitration?
I think I would link this back, and I'm happy with doing all these referred to above, because I think it shows there is somewhat of a coherent thinking on my part, or maybe it's your questions that are drawing out the coherence. But I think it goes a lot towards transparency. And again, I go back to the problem of the function of courts in general, and arbitral tribunals are a subset, I guess, of sort of that very broad idea of courts as adjudicators, is to enrich the supply of legal rules which is out there, right? By applying abstract propositions and statutes and contracts to concrete situations and giving us what could be broadly labeled as precedent. But if we go back to what we were saying before, what we were talking about before, in that all of these awards are confidential, then it's really hard to, one, divine what these rules are going to be and the outcome of your dispute, but also to understand what is this arbitrator X versus Y versus Z capable of, right? In terms of both their intellectual prowess and how they reason awards and how they come out on sort of issues that are relevant to your dispute and to your industry and to your company. And so without having access to, again, sort of without transparency and a proper database of precedents of arbitral awards that get published over time, again, I just want to say, I don't advocate that we do away with confidentiality while proceedings are pending, but that awards be published at some point in the future. But without that, the problem goes back to, and I think it fuels the other problem we were talking about, which is both external counsel are put in an awkward position where they can't really make a recommendation that is backed by data, right, or anything that is truly objective. It's always very impressionistic because you only have impression to draw upon. And yes, even large firms will have the experience of arguing before a given arbitrator only a handful of times. And if that's not the case, then there's something wrong because you have a problem of conflicts, right? But that means there's only a very limited universe from which we can glean information about arbitrators. And that's truly problematic. And why is that problematic for diversity? And I appreciate I'm going on and on about this. But I think it's problematic because there is less incentive to pick somebody new when you have this asymmetry of information rather than go with the tried and tested which is somebody who's already well established, but maybe not for the right reasons. And maybe some people just get a lot of appointments because they have a lot of good connections, and they get appointed, and appointments tend to bring more appointments. And so it's sort of this vicious circle where we're appointing the same people. Some of them are wonderful, some of them might not be, but how can you tell? So.
I'd like to go back now to the fact that you provide a phenomenal 360 view of arbitration. You've now been an in-house role for almost a year and have vast experience as external counsel and also serve as an arbitrator. So I'd love to hear, what would be your tips and your notes to self that you would have give yourself now that you've had the in-house perspective? Which are the notes to self that you would have given yourself when you were back in private practice?
I think specifically on sort of procedure and arbitration, as we were talking now, I think it's about embracing these things that we are talking about. It's about looking at arbitration as something which is tailor-made and which has to be fit to purpose, and just being more creative about how to go about devising the procedure. And this both in sort of engagements with opposing parties, counsel, but also in advising my own client as to how we can take steps to be more efficient, how we can take steps to appoint more qualified arbitrators who will bring a diverse perspective to the table, and how to do all of these things. And that means breaking away a little bit from the mold and just thinking outside of the box more. And I think clients, and I certainly as a client now, truly appreciate when external counsel have a candid conversation and say, hey, this is how we typically do it, but why don't we do it this way? There's so many things that I believe are underexplored. A lot of that will, of course, go through the fact that, especially for certain firms in the Northern Hemisphere, the practice is to pay hourly fees, and hourly fees don't necessarily align clients' interests with outside counsel's interests in the best way possible. And so if you're outside counsel and there's as I said, sort of a tried and tested way of doing things, a template, and the template entails you're going to get a lot of leverage, putting a lot of junior attorneys doing a lot of document review, then why would you move away from that? Because it's going to hurt your own bottom line. But I think this is where in-house counsel also need to get sufficiently sophisticated and educated about arbitration to say, no, we're gonna forego document production. I just had an arbitration now where opposing party was actually quite reasonable, but it was almost this game of chicken where both sides knew that document production didn't make a lot of sense. This wasn't a massive dispute. It wasn't a dispute that truly turned on sort of evidentiary issues. It was more a contract interpretation thing. But neither side wanted to reach out to the other side and say, hey, should we just do away with document production? Because it's in the calendar initially, because it was put there. But then after the first round of exchange of submissions, I think everybody realized, let's do away with this. And it needed a little bit of a push from my own external counsel. We're very good about this, and we had a conversation. And then, to my surprise, external counsel for the opposing party and the opposing party were also very reasonable. And we all came to the conclusion, we're just going to put good money after bad. I don't think we need this. They didn't think we needed it, so we did away with it. And I mean, that has both shortened the proceeding. It's obviated costs for both parties. Maybe the lawyers will come out losing in the very short term, but at the same time, as an in-house counsel, and I appreciate the advice of my external counsel who's on board with this idea much more than I would have if I felt like I'd been taken for a ride. And I mean, for me, this is all, I wouldn't say easy, but it's easier given my background because I can test these assumptions. But it's a real encouragement to external counsel out there to really put the company hat on and the client hat on and just think about it from the other side. So that's one thing. And I've been going on for a long time, but it was tips that I would give to myself, right?
Absolutely.
So the first tip is be courageous to go for fit for purpose solutions. And I think the second thing also has to do with courage in a way, which is, and this goes well beyond arbitration, but it's just give actionable advice. A lot of the time, external counsel are in the position where there are, of course, business considerations, and a lot of things ultimately boil down to a business decision. And even as in-house counsel, you write a memo to the CEO and you say, hey, these are the pros, these are the cons, these are the risks. ultimately, you have to somehow juggle all of these competing interests and come out with a solution, and it's a business decision at the end of the day. But I feel like a lot of external counsel are very shy to give proper, actionable advice and recommendations, and clients truly appreciate that, especially when you're dealing with matters which are not necessarily your cup of tea. And for me, that's everything else except arbitration. So I truly appreciate when counsel actually give me actionable advice and say, we should go this way rather than that way. There are commercial decisions, but this is how I would do it if I was sitting in your chair. And so I think that's the advice I would give myself some years ago.
Thank you so much, Guy. This has been a wonderful conversation, very valuable input for all of us. And thanks again, Laudo, Fernando, and everyone at Canal Arbitraje for the great organization and having us here today.
It's been an absolute pleasure. I just want to extend again words of gratitude to you, to King and Sporting, and to Canal Arbitraje. And hopefully, hopefully along the trend of what we're talking about now, these sort of conversations will add some food for thought. Thank you very much.